A lot of people assume that patents are really only useful for huge companies and are kind of useless for startups. Well, if you approach it the old way, then that might actually be true. I myself am a startup guy, entrepreneur, and I figured out how to make patents most useful for startups. I'm myself an inventor on over 20 patents that have been licensed by major international companies. And I've also invested in startups both through patent services and also just regular cash investments. My background is I graduated from MIT and also Carnegie Mellon. I worked at a patent law firm in New York City, and I'm also a registered patent agent. And when people found out about what I've done with some of my own patents, they've contacted me, other entrepreneurs, and so I started a company called American Patent Agency, which helps other startups and entrepreneurs figure out the patent landscape. So for the startups that I've been involved with, the patents has helped them with the legal protection of their idea, legitimized their concept, attracted media and press attention, and also gave them higher valuations both during fundraising and during acquisition. Now, I've been saying this kind of stuff anecdotally for many years based on my personal experience, but just earlier this year, the Harvard Business School completed a study, and they found that an initial patent increased companies' sales growth by an average of 51% over 3 to 5 years. They found that a delay, conversely, in a patent, despite it eventually being approved, could negatively impact a startup's success, and that each year of delay in a patent grant would slow a sales growth by as much as 21 to 28%. So how is it that exactly that patents help a startup? Well, an approved patent increases the probability of securing venture capital investment. It's also true about angel investment as well. This is what Harvard Business School study found. Facilitate access to investors and alleviates concern about ability to monetize. So probably a lot of people ask, first of all, what is patentable? That's usually the first question I get. What is patentable? Well, the founders, so some background information, the founders placed a large importance on patents. So what people don't know is Thomas Jefferson was also the first patent examiner, and he introduced the patent bill as the third bill in the first Congress. And just to emphasize how important founders placed on patents, in the United States Constitution, patents are in Article 1, Section 8, a power granted to Congress. Congress has the power to promote science and useful arts by securing for limited times to authors and inventors the exclusive right to their writings and discoveries. So this is copyrights and patents. Okay, so as you saw by the Constitution, Congress gets to decide what is patentable. So Congress has decided that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement can get a patent. So what does that actually mean in practice? Well, the Supreme Court gets to decide what did Congress mean. So the Supreme Court explained in 1980 that anything under the sun made by man is patentable. So for example, they held that a genetically modified microorganism is patentable. Why? Because it was modified by man or woman. So some of the most ridiculous things have been patented. So a patent doesn't mean that your company is going to be successful, not at all. Despite the broad brush of anything under the sun being patentable, some things are not patentable. So the Supreme Court explained that laws of nature, physical phenomena, abstract ideas are not patentable. So for example, a new mineral, it would not be patentable if it was found in the ground. If you found a new plant in the wild, that would not be patentable. So similarly, Einstein couldn't patent E equals mc squared, Newton couldn't patent the law of gravity, etc. So basically, laws of nature are not patentable. Also, abstract ideas are not patentable. So the most recent case was about Alice versus CLS Bank, which is a Supreme Court case about software. And in this case, the Supreme Court said that an abstract idea is not eligible for a patent. Taking a mathematical algorithm and just making it on a computer is not patentable. There has to be an inventive concept that distinguishes an abstract idea from a patentable software invention. That needs to be explained first. So similarly, genetic sequences are not patentable. So a genetic sequence is something that's found in the wild, and just isolating it from the cell does not give rise to a patent. I already explained that mathematical algorithms are not patentable. So just to explain how software can be patented, an abstract mathematical algorithm is not, but a specific machine that produces a specific, useful, concrete, and tangible result can be eligible for a patent. Now, what is a patent? So I brought examples of a patent. Okay, so this is the patent for the PageRank algorithm. So the PageRank algorithm, for those that don't know, is what Google uses to do search results. So it's a recursive definition. Well, this patent is a patent on the PageRank system. It's not a patent to an algorithm, as I'll explain in a second. It's a patent to a computer implementation of the algorithm. So on the first page, you see the patent number, the inventors. You see that it's assigned to Stanford. So what is this? What is this document? Well, this patent, it's a right to exclude others in the United States from making, using, selling, offering for sale, or importing into the United States the claimed invention. This document doesn't give Google or Stanford the right to do anything. It doesn't let them or give them a right to violate any laws, doesn't give them a right to export the invention. This only gives you the right to exclude others. So one of the most important parts of a patent is the specification. And the specification is an engineering document basically that explains how to make and use the invention. The parts of the specification are the background, and the summary of the invention gives a summary. The detailed description is the engineering document. And of course, the patent also has drawings if they are necessary to understand the invention. After the drawings and the detailed description is the claims. The claims are the most important part of a patent. So in the claims, so as you saw in this document, they have both process claims, which are methods. Okay, they don't have any machine claims, but they have an article of manufacture claim, which are claims 18 and 19. So we already talked about claim 1 of the Google patent. So if you look at claim 1 closely, claim 1 is a computer implemented method of scoring a plurality of linked documents comprising. So since it's a method claim, all the elements of the claim are steps. So obtaining a plurality of documents, assigning a score to each of the linked documents based on scores of the one or more linking documents. That's the recursive definition right there. And processing the linked documents according to their scores. So it's a very broad claim for the Google's first patent. But what would happen if you wrote such a broad claim that the examiner rejects it? Well, when you first file a patent, a claim is like a fence around a piece of property. So, but what happens if your neighbor says, well, wait a minute, my cow was already there. So those are cows. So if your neighbor's cow was already there, you can't get it. So same thing as with the patent. If you make a fence this big, and the examiner finds other people have already invented stuff within your fence, your claim would be rejected. So then what you do is you say, okay, fine, I'm only going to take the land that nobody has been on before. So you modify your fence and you draw your fence like this. And that's what happens during patent prosecution, is you make the claim so that it's not where somebody has already done something. Once you've done that, then the examiner says, okay, approved, and your patent covers this part. Another example of a claim is a composition of matter claim, chemistry. A composition comprising a solid, liquid, and a gas. That's an independent claim. Composition of claim 1, wherein the solid is a salt. That's a dependent claim because it depends on claim 1. Composition of claim 2, wherein the salt is sodium chloride, depends on claim 2, also dependent claim. Now, for those people that are in biotech, there's an example of a biotech claim. A method of producing human protein AAK1 comprising the steps: transfecting suitable host cells, culturing the cells, and recovering the cells. Now, of course, all of these steps are well known, so the only novelty in this claim would probably have to be with the genetic sequence of AAK1. Okay. So now, how does the claim work? So I explained earlier that if you are within the fence, then then your patent is either invalid if it came before the filing date, or they're infringing if they came after. So once your patent gets approved, if somebody else's cow goes inside your fence, they have to pay you, or you can block them from doing that. So how does that work? Well, here's an example of a claim: an apparatus comprising A, B, and C. So a claim defines the minimum required for infringement after the patent gets issued. So if the claim says an apparatus comprising A, B, and C, and the accused product says A, B, and C, well, that's obviously has infringement. Everybody understands that part. Well, what happens if you have A and B? Well, if you just have A and B, there's no infringement, because the claim says you have to have at least A, B, and C. So if you just have A and B, you don't infringe. The more complicated thing that people sometimes might not understand right away is if you have more than the claim, then you're still infringing. So what this means in practice, if you make an improvement on somebody else's product, neither of you would be able to use the improvement unless you agreed. Because if you made an improvement on somebody's patented invention, you couldn't use the improvement because it requires you to use his invention too. And he could use make his invention, but he couldn't make the improvement. So what happens if you infringe on somebody's patent? Well, you have the right to a private suit, a civil action in the United States District Court to recover lost profits, reasonable royalties, damages for willful infringement 3 times as much, or you can say your cow can't come to my land and eat my grass. That's called an injunction. So the important thing to remember, no such thing as patent police. No police is going to knock on your door and say you're infringing the patent. You can't call 911. It's not going to work. Okay, what is non-obvious? So in order to get a patent, your invention has to be novel and non-obvious. So in order to explain what is novel, I have to tell you what is not novel. If something is not novel, then it's novel. What is not novel? So any publicly accessible information is not novel. So for example, prior public uses, printed publications. So let me give you the most extreme example from one of these court cases. Let's say you wrote a thesis, and let's say this was during the Cold War, and you were working in a research facility in the Soviet Union in Siberia, and you did your thesis on that, and you wrote it in Russian, and then you stored it in the vault, in the Soviet Union vault, in the Siberian desert for tundra, okay? And it was closed shut. So the key to a printed publication is accessibility in theory. So if that vault can be unlocked by someone in the public, in theory, that's the only thing that matters. It doesn't matter that nobody actually went in and looked at it. So to use a less extreme example, let's say your thesis was stored in a library in California. Well, if your thesis is indexed only by your name and title, then it's not publicly accessible, because how would anybody ever find that? Even in theory, it's impossible. But if it's indexed by subject matter, even if not a single person in the entire world ever read it, it's considered a printed publication. The only thing that matters is, could someone look at it in theory? Could they find it by subject matter, and could they translate it? Then it counts. Now, this is where I get into the nitty-gritty of how to find out whether something is prior art. So anything that's a printed publication or publicly accessible could be prior art, but only if certain conditions are met. So when is a printed publication a prior art? Well, there are 2 types of printed publications. One is something other people did, and another is something that you did. So that would be your competitor. That would be your best friend. It could be your enemy, doesn't matter. Somebody other than you. So other people's work counts as prior art against you under the following conditions. So AIA 101A1. Any claimed invention that was available to the public, I already explained what available to the public meant. It doesn't mean anybody actually looked at it, it just means that they could have looked at it, before the effective filing date of the claimed invention is not patentable. And the other thing is, any claimed invention disclosed in patents or published patent applications with earlier filing dates which names another inventor is also unpatentable. So let's look at Google's patent. This patent has an effective filing date of January 10th, 1997. So if Yahoo had the PageRank publicly available on January 9th, 1997, this patent would be invalid. And that's because the claimed invention was available to the public before the effective filing date of the claimed invention. Similarly, let's say Yahoo filed a patent with a priority date earlier than January 10th, 1997. Then Google's patent would also be invalid under this criteria. Any claimed invention disclosed in patents or published patent applications with earlier filing dates. So either the other person made the invention publicly available before you filed your patent, or they filed their patent before you filed yours. Those are the two ways in which your patent can become invalid or rejected by the examiner. So now, I already explained other people's work. Well, your own work also counts as prior art. So if you published your invention in your own thesis, and the thesis became an article in the newspaper, in a journal article, then that could also become prior art, even though it's you yourself. That doesn't seem fair, but I'm going to try to explain why it is fair. So the reason is because the patent term starts from your filing date. So if you can publish something or sell it for 10 years and then file a patent 10 years later, you would be blocking people from using something that was already publicly available for another 20 years. So it would not be fair at all. So that's why if you publish something or release your product, you only have 1 year to file for a patent. So if you release your app on the App Store today, you have 1 year to file it. After a year, your patent cannot be filed anymore. In other countries, they don't have that. So in other countries, if you don't file the patent before you release it, you can't file a patent. So similarly, if you filed for a patent 10 years ago and it gets issued, you can't file another patent on something similar 10 years later. You only have 1 year to do that. So if you have multiple inventions that are similar, you only have 1 year to file them. You have to file them pretty much at the same time. Okay, how do you search for prior art? Well, in my opinion, I think inventors should search their own prior art. The best one, of course, is Google Patents. Google Patents, you can search everything. It'll search patents, patent application, publications. It'll also search foreign patents. Google Scholar is the best way to search for non-patent literature, like other people's articles and so on. Free Patents Online also works, and USPTO.gov, obviously it'll work, but the interface is a bit messy. Scientific and technical databases, of course, can be searched, libraries and so on, but usually I use Google Patents and Google Scholar. Now, the most important thing. We already talked about what is not novel. Now let's talk about what is not obvious. This is the thing, besides what is patentable, this is the second most common question I get, what is not obvious? But the way the Congress defined non-obviousness is if the difference between the subject matter sought to be patented and the prior art are such that the subject matter as a whole would have been obvious at the time the invention was made to a person having ordinary skill in the art to which such subject matter pertains. That is the definition of obviousness. If it's not this, then it's not obvious. So what does that mean in practice? Okay. Although it's up to Congress to define novelty and non-obviousness, it's up to the lower courts to explain what that means. So in one case, Graham versus John Deere, the Supreme Court explained that a new invention, even though it's novel, may still not be patentable if the difference between the new thing and what was known before is not sufficiently great to warrant a patent. So in order to determine non-obviousness, first you determine the scope and the content of the prior art. Then you determine what is the difference between the prior art and what you're trying to patent. So in this case, is a very simple example. The prior art is A, B, and C, and you're trying to patent A and B. Well, the difference is not C, but taking away C. And then you have to determine what is the level of ordinary skill in the pertinent art. So is it a computer science invention? Is it a biotech invention? You might need to have a PhD. So what might be the level of skill of the ordinary art in one field might be vastly different from another. But once you've determined that, then you have to ask the question, to that person of ordinary skill in the art, would it have been obvious to take away C or not? And what are some evidence that you can use to figure out whether or not it would have been obvious or not? Well, commercial success is one example of non-obviousness. So let's say somebody had an invention A, B, and C. And let's say that invention is already, patent is expired, everyone is using it. And you take away C, and you sell hundreds of millions of dollars worth of product just by using A and B by taking away C. That would be a reason of non-obviousness. Because if anybody could just take it away, then why are you so successful? Another example of non-obviousness would be long felt and unsolved need. So let's say C was toxic, and you figured out a way to take out C, but it still works with just A and B. Well, if C is toxic, then it would have been long felt and unsolved need. Failure of others. Let's say lots of other people tried to take away C but kept failing. Taking away C is usually most relevant in chemical inventions, not so much in software. So let's say people knew that C was toxic, and they've been trying to figure out how to get rid of it, and they've been able to. Well, if you figure out how to do it, that's failure of others. Unexpected results. Let's say you took away C, and you got this amazing, making it much more efficient. That would be unexpected results. So just some case studies. We were able to obtain 2 patents for a company called Prediction.io within less than 4 months from filing, and that was just in time to get their acquisition by Salesforce. So they were able to use that in the acquisition negotiations. That's why getting patents quicker can make a big difference. Another case study is sometimes if you're not in software, you need to raise a lot of money to make a product. So for example, oil and gas, they had to raise over $35 million to build their machine. In that case, you definitely need a patent, or multiple patents. And that's because unless it's protected and nobody else can replicate it, why would someone invest that much money? Whereas in software, you can just make the app and get revenues. If you have a capital-intensive industry, you absolutely need patents. Okay, so Thinx is another company that we've worked with, and they make a reusable underwear that eliminates the need for pads and tampons. And this company is founded by 3 women entrepreneurs, and this is a case study of how design patents can be useful. So they invented a system that can capture liquids without using pads or tampons. And the utility patent, there's a lot of prior art out there. As you can imagine, underwear has been developed for many, many years. So getting a utility patent is very difficult. So we help them get design patents. Design patents cover ornamental appearance of something. So this is a picture from one of the design patents. So the design patent covers the appearance of something. So it's possible to get both utility and design patents. And design patents give you a patented status before your utility patent might get approved many years later if the examiner is really stubborn. So what is a design patent? A design patent covers the ornamental appearance of an article of manufacture, which could also include computer animated or computer graphical user interfaces. So a software company called Mixbook, they're in Palo Alto, they sell photo books. So you can order a photo book on the internet. So we got them design patents on both the photo book itself and the user interface that they use to design the photo book. Now, international patents. So first of all, the US patent will only protect you in the US. Here's the thing. For an internet invention, that might be all you need. Let's say you have a competitor in Japan and they publish a copycat. Well, if that website is available in the US, which if it's on the internet it surely is, then they're infringing your United States patent. But for everything else, everything that's not available on the web, your US patent will only protect you in the US. It's not going to work internationally. No such thing as an international patent. There's such a thing called an PCT, International Application. That's the closest thing that comes to an international patent, but you still need to file patents in each individual country within 30 months. But it gives you more time to file international patents. The other thing that's available is European Patent Office. you can get a patent in the European Patent Office that will be valid in all countries. The other thing to remember about international patents is you have absolute novelty, which means that you have to file for the patent either in the US or internationally before you release it to the public. The other treaty is you have the PCT International Treaty. So under the Paris Convention, you only have 12 months, 1 year, to file in other countries. With the PCT, you get another 18 months for a total of 30 months. And the PCT allows you to file in one country, so you can file a PCT in the US Patent Office. And then it gets examined by the US examiner, and you get an international search report. And if that doesn't give a patent automatically, but if that's positive search report, you can use that to get a patent automatically in almost any country, but not completely automatically. You still have to file it, but it gets accelerated, and it almost always gets granted, but not 100%. So the PCT saves a lot of money and a lot of time, but it doesn't eliminate filing in every country, is the bottom line. Okay, so some of the tips that I've learned for startups. Accelerated patents. Take advantage of track 1 examination and provisionals. And that's because, let's say you're IBM. Like I explained before, you might not need to enforce the patent for many years. So if you're IBM and you have hundreds of patents, it doesn't matter whether it takes you 2 months or 2 years or 5 years, doesn't matter. Because you're not going to use it for 5 years anyway. But for a startup, it can make a big difference because your funding round might be in a few months or a year or less than that, and that can make a big difference for you raising money. Whereas IBM isn't always going to be able to raise money on the public markets, no matter whether they have 10 million or 10 million and one patents. So therefore, for startups, I found that taking advantage of track 1, which is an accelerated procedure at the patent office, can make a difference. Also, provisionals can save you a lot of money if you're not sure how your product might evolve. So if you're not sure how your product might evolve, provisional can secure your date for 1 year. And then, like as I explained before, you can add more matter to the non-provisional before the end of the year. So I recommend you use patent agents or attorneys that understand the technology that they're working on. That's obvious, kind of, yeah. The other thing I recommend is you have clear communication between the inventors, the patent agents or attorneys, and the patent examiner. So a patent examiner is also an engineer. They're not lawyers. So patent examiners are hired by the patent office. They're government employees, but they all have a background in engineering. So usually what's most convincing to them is arguments based on technical aspects. Trying to make legal arguments, complicated legal arguments, usually doesn't help much. So when you're talking to the patent examiner, you have to convince them that your invention is novel and non-obvious. If you've done that, they'll give you your patent. There's no magic to it. You can avoid rejections, especially multiple rejections, by going through prior art searches and crafting relevant claims. So if you try to claim the entire state of Wyoming when in the Homestead Act, and there's all those cows there, you're going to be getting, each time you modify the lines, you're going to keep getting rejections. Design patents are also good because they're really quick. You can get a design patent in only a couple of months sometimes, especially if it's accelerated. And you should use design patents either because you can't get a utility patent or you don't qualify for it. Okay, concluding remarks. So the last thing I want to leave off with is I am a registered patent agent and I took the patent bar exam, so I studied this stuff, but I'm not a lawyer. I never went to law school. Most of you almost certainly aren't lawyers. You never went to law school. So therefore some things might make you a little bit confused. So I'd like to explain this. What is the difference between natural law versus man-made law, law versus public policy? I think these are two things that a lot of engineers don't completely understand. They get really confused. So let's talk about natural law versus natural philosophy. What is the speed of light? That's a natural law. 299 million meters per second in vacuum, right? That's a natural law. This law, anybody can validate by doing an experiment with light, right? Michelson-Morley experiment, etc. And we also know that this light speed is independent of the state of the observer or the state of the source, right? Natural philosophy, why does the universe exist? Nobody knows, right? So we can all agree that the speed of light is this, but nobody will ever agree, no two people will probably ever agree, why does the universe exist, right? So man-made law and public policy is similar to that. Whenever you think about patent laws, I want you to stay away from trying to think about why this is. Because man-made laws are laws set by man and woman, right? So a man-made law is, what is the speed limit in Palo Alto? Well, I did research on this topic, and actually in the state of California, the speed limit is 25 miles per hour within any city limit unless posted otherwise. Why is that? Why is that the law? Well, the people in Sacramento decided this is what it should be. So what should be the minimum drinking age? Everybody knows that the answer is 21. But what should it be? Well, that's a public policy question. Nobody knows. You can debate. There's no debate about this question, but there's a lot of debate about that question. So patents are the same way. What is patentable? Well, I've already explained to you what is patentable. That is something that's determined by Congress, and it was determined many years ago, and it's always being changed. But the point is, what is patentable is not really open to debate. It's whatever Congress and the courts have determined it to be, right? Now, if you're debating or if you're deciding on who to vote for, then you can debate about what should or shouldn't patents be, etc., etc. So I hope this helps you understand the kind of questions you should and shouldn't be asking. So if your goal is to understand patents, then you should focus on these questions and not be distracted by those questions. But if you want to understand society and you want to understand how society can evolve in the future, etc., then these are all excellent questions. So for those that slept through the talk or that skipped through the talk, almost anything under the sun is patentable. That is made by man. But the most important thing to remember is the 1-year bar, which is you have 1 year from your own public disclosure to file for a patent in the US. Doesn't apply in any other country. You have to file it before you disclose it publicly. But in the US, you have 1 year. The claims are the most important part of a patent. And the last thing I only touched on briefly, the moral foundations of patents are open to debate and probably will be for a long time. So I would like to end this discussion with a totally different topic on the other side of that last slide, which is, are patents and copyrights morally justified? There's an interesting paper published a while ago, Harvard Journal of Public Law and Policy, entitled, Are Patents and Copyrights Morally Justified? So if those kind of questions interest you, then there's a lot of writing on this topic out there. My personal opinion is very complicated. I always think about it. So my current opinion has to be based on where does property come from. So under the Homestead Act, you got land, right? And you had to be first, but it wasn't, I actually didn't explain, it wasn't enough for you to be first. If you just went to Wyoming or Utah back in the day and you put up a fence, you couldn't get property that way. You had to do something more. You had to develop the land. So in order to obtain land under the Homestead Act, you had to be first, but you also had to develop it, which means you had to either cultivate it into farmland or you had to build a house, a homestead. So if that's the basis of property, the basis of property is you put effort into making something, and therefore you have the right to it. So if that's the basis of property, which is itself open to debate, but if that is the basis of property, then certainly patents and copyrights are morally justified on the basis of the intense amount of effort that goes into creating this thing. So in order to get a patent, this also explains another aspect of it. In order to get a patent, it's not enough for you to be first. It's also not enough. You have to actually explain in detail how to make and use the invention. And that's important because when your patent expires, for two reasons. Before your patent expires, people can improve on it. After it expires, anybody can use it. So to get a patent, it's not enough for you to be first. You have to be the first one, and you also have to explain in enough detail that anybody else can make and use what you've done. So if that's under those assumptions, then I would say yes, they are justified.